A relic of Louisiana's Jim Crow past, split jury verdicts were ruled unconstitutional by the U.S. Supreme Court 2 years ago. But recently, the court decided that the decision didn't apply to people who had already been convicted by non-unanimous juries. So there are some 1,500 people convicted by non-unanimous juries still in prison. But a decision by a district court judge may have just given them hope. The judge in that case says the ban on non-unanimous jury convictions should be retroactive. Tonight we talked to the lawyer who argued that case. I'm happy to be joined by Hardell Ward of the Promise of Justice Initiative, who represented David Nelson in the case in question. Thanks for coming on, Counselor.
Thank you for having me.
So we've talked about non-unanimous juries on Making the Case before, but for those viewers who are unfamiliar, can you give us a brief primer on what they are?
A non-unanimous jury or a Jim Crow jury is a situation where someone is convicted, but the jury did not reach a full unanimous 12-0 jury verdict. It was either 11-1 or, in this case, 10-2.
Now, tell us a little bit about David Nelson and his case.
David Nelson's case was a tried second-degree murder case that the jury reached a decision of 10-2 manslaughter, a lesser included charge. The two dissenting voters were black women who did not vote guilty, but in spite of that, Mr. Nelson was still found guilty and was still sentenced to 30 years incarceration.
Now, this case will only affect Mr. Nelson unless a DA chooses to appeal the ruling to the Louisiana Supreme Court. Can you explain to our viewers why that is, and do you expect that to happen?
We do expect it to happen. The reason is currently after the Edwards v. Vinoy's decision, which held that the Ramos decision would not be held retroactive on federal habeas, there isn't any overarching decision in which other individuals could cite to in their case. So now it's up to each individual person to have a hearing and argue on their own behalf that the Ramos decision should be applied to them, be held retroactive to grant them relief. So we do expect the state to take what's called a writ in Louisiana to the circuit court and then to the Supreme Court. But it's possible they do not, and the reason they may not is to stop it from being overturning, so they can continue to keep these over 1,500 people incarcerated.
Mm-hmm. Well, we know that New Orleans DA Jason Williams, who we've had on the show before, has adopted a very progressive approach on this issue, vowing to examine cases where people have been convicted by non-unanimous juries. Are other district attorneys taking similar approaches?
At this time, no. There are conversations being had between our office and district attorneys about potentially doing so. In the last legislative session, a new law was passed that explicitly allows district attorneys to do what Jason Williams has done. It was already legal, but the new law would allow district attorneys to review cases and potentially offer post-conviction plea agreements to seek some relief. But at this time, no DA has come forward and has expressly stated that they're going to do these cases. There are some conversations about certain particular cases, but at this point in time, there is no current movement on that end.
Now, is David Nelson the only case you have that has a possibility of having this decision be applied retroactively, or do you have others?
We have many others. After the Edwards decision was rendered, we had filed motions to stay awaiting that decision. After that decision, we have filed motions to lift stays, and now we're moving into the hearing process. The previous week, I actually had about 7 post-conviction hearings. Many of the hearings were continued into the future. David Nelson's hearing moved forward, and we were successful on. So we do have many other cases, some still in Calcasieu, where we're hoping that the persuasive authority of this decision resonates and gets relief for the other individuals similarly situated.
Now, what other strategies is the Promise for Justice Initiative using to address the issue of non-unanimous juries?
First, education. The Jim Crow jury law in Louisiana existed for over 100 years, mostly without individuals even knowing. So we're trying to educate the community, educate that this is still a problem, There are still individuals who are suffering. Louisiana still has an explicit racist white supremacist law on the books, and it's still being enforced. There are still individuals being held, many with life sentences, with their constitutional rights violated. There are still individuals, there are still mothers and fathers and brothers who are still incarcerated, who still should receive a remedy under law. So that's the first strategy. And then there is a litigation stride of being proactive, of addressing the district attorneys, of going to these hearings. You'll find in a lot of times most post-conviction hearings are done without an attorney, but we committed before the Edwards decision, and we recommitted after the Edwards decision to seek these cases as far as we can, so that our clients' voices are heard and that relief is granted.
All right, Hardell Ward of the Promise of Justice Initiative, thanks again for being here.
Thank you for having me.